Hello friends. So today we are talking about another very important topic on cyber law, and that is dealing with cyber jurisdiction. So in this topic we will discuss about jurisdiction first, the meaning of jurisdiction, then we will come to cyber jurisdiction, then we will also discuss kinds of jurisdiction, then after we will discuss about the traditional law in India and the provisions which are dealing with jurisdiction of the courts under these various laws. Then we will also discuss the provisions relating to cyber jurisdiction under the IT Act 2000. And finally, we will also take some of the important case laws which are decided by the US courts and further which are implemented by the Indian courts while interpreting the provisions of the cyber jurisprudence. Now, yes, coming to the meaning of the jurisdiction. So before we come to the cyber jurisdiction, so it is important for us to understand what is the meaning of the word jurisdiction itself. So this word is taken from the Latin language and is composed of two Latin words. First is juris and the other word is dicere. So collectively it means, both these words, it means to speak. So overall the word jurisdiction, it means the authority of any organ or a body to comment upon the legal matters which are brought before it for adjudication. So applying this word or the definition of this word to the cyber jurisdiction, then it means cyber jurisdiction, it means the uh, authority of the courts or the government or its agencies or the courts which are dealing with the internet related issues or the persons who are using the internet. So this authority of the courts as well as the government or its organs, that is known as the cyber jurisdiction. Now next we'll discuss with kinds of about kinds of jurisdiction. Now we will divide jurisdiction into three various kinds. The first one is prescriptive or legislative jurisdiction. Second one would be enforcement jurisdiction, and the third one would be adjudicative or judicial jurisdiction. So coming to the first one, that is prescriptive or legislative jurisdiction. So very simple it is. Uh, Prescriptive or legislative jurisdiction, it means the authority of uh, the legislative bodies to enact the laws and to make the laws. Now, same if we talk about the parliament in India or the state legislature, if they enact the law or they make certain kinds of law, so this authority of the legislature, the state as well the government, is known as the legislative authority. So this is what the legislative jurisdiction means. That under the Constitution of India, we can also see that there is a clear-cut division of certain subjects in the union list, state list, and concurrent list. As we see, there are 97 subjects under the union list on which the central government can make the law. There are 66 subjects in the state list on which the states can make the law, and likewise there are 47 subjects in the concurrent list on which both the center as well as the state, they can make the law. So talking about, if the examples we talk about of the prescriptive or the legislative jurisdiction, so so many examples are there before us. Talking about IPC, Indian Evidence Act, Indian Contract Act, or other kinds of laws. Now, all these laws, these acts, they are the example of prescriptive jurisdiction or legislative jurisdiction. Second come enforcement jurisdiction. So enforcement jurisdiction, it basically means the right of the state to enforce legislation through various modes. or through various agencies of the state. For example, the police administration, by the investigating a crime or arresting the suspects or the accused. Now, this kind of jurisdiction, where the laws which are enacted by the legislature, they are enforced by certain agencies to whom this work is assigned. Now, this kind of jurisdiction to enforce the laws which are made by the legislature is known as the enforcement jurisdiction. Now, the third kind of jurisdiction is the adjudicative or judicial jurisdiction. So, this kind of jurisdiction, it means the authority of the courts or the tribunals and the other bodies or persons who are exercising the judicial functions now to hear and decide the matters which are dealing with the with the matters which are brought before these courts or before these bodies or persons for the purpose of administration of justice. So when the courts, they hear a case, or the tribunals, they hear a case and decide a case, so this kind of authority of the courts or the tribunals to hear and decide the cases is known as adjudicative or judicial jurisdiction. Now, this was about the kinds of jurisdiction. Now we come to the why cyberspace is a unique in terms of jurisdictional issue. We talk about that there are certain issues with the cyberspace when we talk about the jurisdiction. Now, why these issues are there? Why we are not able to apply those laws which we are applying in the physical world or in the real world, what we say. Now, there are so many reasons because of the nature of the cyber law itself or the cyberspace itself. Now, it becomes certain, difficult sometimes that the law of the real world or the physical world that cannot be applied in the cyberspace or to the activities which are there in the cyberspace. Now, these unique features of the cyberspace, they includes, first one is that cyberspace, it is considered as the borderless territory. And because of this reason that it is a borderless territory, so you see that in the physical space when we talk about, so the most effective mode of jurisdiction which is applied in the physical space, that is the territorial jurisdiction. But the territorial jurisdictional rule that cannot be applied in the same sense in the uh, in the cyberspace. Reason being that it is cyberspace, it is not limited as we talk about the real world or the physical world. Second is that the cyberspace, it has an unlimited access. There is no limit to the access of the internet or the internet related activities. So again, sometimes the issues which are brought before the courts, sometimes which are relating with the internet or the internet activities, now they are so technical that the rules of the real world or the physical world, that becomes difficult for the courts to apply those rules in the same manner. Third one is that cyberspace, it is available everywhere, or the internet, it is available everywhere. Ubiquitous, we talk about that, since the nature of the cyberspace is such that it is available 24/7 to all the users. So not only it gives that space or that space also for the happening of the good things, as well as it also gives the same amount of pace for the uh, illegal functions or the illegal work for the those persons who are who are exercising the internet for doing certain illegal work also. So the criminals, they can also use the internet space with that same pace for which it is used for doing certain good deeds. And the next one is the spontaneity of the internet world or the cyberspace. It is such a space where the things happen spontaneously, very fast. The things, they happens at the internet. So again, due to these various activities which are there on the internet, which are related with the cyber issues, cyber world, so it becomes an issue when we talk about the jurisdictional issues in the cyberspace. So now talking about the jurisdiction rules in India, or the traditional law of India, which talks about the jurisdiction of the courts. Now the first we'll talk about the Code of Civil Procedure. And the Code of Civil Procedure, it provides for jurisdiction from section 15 to 20. And we will find that the rules which are there under CPC, they are defendant-centric rule. The first thing it says that, and you will find in CPC, it says that the suit, every suit that is to be instituted in the lowest court, which is having the jurisdiction to decide that case or to hear that case, one thing. Secondly, it also provides for provisions where the suit is for the compensation of the wrongs done to the movable property. So for that, it provides that in that case, the plaintiff can institute the suit either in that place where the movable property is situated, one thing, or otherwise it also says that if the plaintiff wants to institute the suit, he can also institute the suit at that place also where the defendant resides or personally works for gain or carry on business. So it is the option of the plaintiff where the suit is to be filed. Now both those places from on from where the property belongs, or at those places where the defendant is residing or carrying on business, he can file the suit. Now it also provides, CPC also provides under section 20 the provisions if there are more defendant than one. Now it may happen sometimes that there are more defendant than one. Now in that case again, the plaintiff can file the suit in any court where any of the defendant is residing out of those multiple number of defendants. So the plaintiff can file the suit before any court where any of the defendant either resides or carry on business or personally works for gain. So overall, you will find that the rule which are there under the Code of Civil Procedure, that is a defendant-centric rule. Now coming to the Indian Copyright Act 1957, now section 62 of the Indian Copyright Act, it provides for a different kind of rule when we talk about the jurisdiction of the court. And it says that if the suit in respect of the infringement of the copyright is there, now the suit can be instituted by the plaintiff in the district court which is having the jurisdiction to hear that case. So here the difference you will find from CPC is that the CPC rules, they are the defendant centric, but here the rule is not defendant centric, rather it is the plaintiff centric rule. So the persons whose intellectual property rights they are violated by the defendant, so here the plaintiff can file the suit before the district court in whose jurisdiction that infringement is there. Now talking about now the Criminal Procedure Code. So the Criminal Procedure Code, it provides for the jurisdictional rule from section 177 to 188. And the Criminal Procedure Code, it says that the place of jurisdiction shall be the place where the offense is committed. So, and secondly, it says that the court in whose local jurisdiction the crime is committed, that shall have the jurisdiction to try the case. So it doesn't matter that from where the accused that belongs. What is the main concern of the courts for the purpose of jurisdiction is that the place of the crime. So the place of the crime, that shall be the place of the jurisdiction as well, in whose local jurisdiction that particular place that follow. So these are the rules under the traditional Indian law. Now we talk about the IT Act 2000 and section 75 of the IT Act 2000. Now when this act was passed, now it extends this act, it extends the jurisdiction of the Indian courts to an offense or contravention which are committed outside India by any person irrespective of his nationality. Now not only that, if a person commits an offense within the Indian territory, and suppose that person fled away from the territory of India, and now he goes to the territory of other country, still the Indian courts shall have the authority over that person to brought that person under the jurisdiction of the Indian courts. But in those cases also, where, if somebody is committing an offense outside the territory of India, and the impact of that particular offense that is felt within the territory of India. So in that case, still the Indian courts shall have the jurisdiction to hear that case and to decide that case, and the accused can be tried under the jurisdiction of the Indian courts. So this is, the section 75. Overall, it means that it gives the extraterritorial operations to the traditional law which were applicable in India prior to 2000, before the IT Act 2000 was made. Now we will take some of the case laws, very important case laws, and which talks about the jurisdictional issue in the cyberspace. And first, we'll talk about two important cases which are decided by the US courts. Then we will take Indian cases in which the rules which were laid on by the US courts, those rules were applied by the Indian courts also. The first case in this regard, that is GPO Manufactured versus GPO.com. Now, in this case, for the first time, the US courts, they differentiated between the websites, and the court said that there are two kinds of websites: active websites and passive websites. And the court said that in case of passive websites, there do not arises any question of the jurisdiction of the court, for the reason being that in passive websites, only the information is displayed on the website, and interaction is not there between the website owner and the user. So if the interaction is not there, obviously there is no question of dispute between the user and the website owner, and so also there is no question of jurisdiction of the court. Now the court jurisdiction that comes into operation when the interaction is there between the user and the website owner. So the court said that where the interaction will be there between the user and the website owner, and due to that interaction, if that interaction is of commercial nature, and due to the exchange of information which happens between the user and the website owner, if that gives rise to certain sort of disputes between the website owner and the user, now in that case the court shall have the authority or shall have the jurisdiction to decide that case. And this test which was laid on by the US courts in this case, that was known as the sliding scale test. After that, there comes although the court in sliding scale, while laying down that rule, that also held that this test cannot be applied to every kind of case. Now the second case, that is Calder versus Jones. And in this case, yet another kind of test was laid on by the US courts. And this test is now known as the effect test. Now, in this case, a California resident, he brought a suit, a libel suit against a national magazine, which was situated in Florida. And in this case, although the defendant, now he argued before the court that in this case the court lacks the jurisdiction, and the lower court where the suit was filed by the California resident, now that were rejected by the court on the ground that the court do not have the jurisdiction in this case. Now, when the appeal was filed, now the appellate court in this case, now it reversed the order of the lower court and said that in this case the court has the jurisdiction. Ultimately, the Supreme Court of the United States, it held that in this case, whenever such kinds of cases are there, the courts needs to see that where the harm is suffered by a person, by the at the time when in such cases where the libel action was brought in this particular case, The court said that it is to be seen that where the harm is suffered, and basically that means that where the effect was felt of the activities which were somewhere carried on by the, in this case, by the magazine owner. Now the court said that since the harm was suffered by the resident in the California state, so in that case the California court, it shall have the jurisdiction to hear and decide that case. So this test, which was laid down by the court in this case, this was known as the effect test. And after this, we come to the Indian cases now. Now, the first case in this regard is Banyan Tree Holding versus Holding Private Limited case. It was decided by Delhi High Court, and the Delhi High Court, it applied the both of the rules which were formulated by the US courts, the sliding scale test as well as the second case, that was the effect case test. So both these tests, they were applied by the court. And the court, Delhi High Court in this case, it said that the defendant must have purposefully availed itself of the jurisdiction of the court by the use of the website. And secondly, there must be the intention to conclude a commercial nature interaction with the user. Now there needs to be certain sort of interaction for the commercial nature between the website owner and the user, and due to that commercial transaction, there must be certain kind of injury or harm to the plaintiff. So if there is injury or a harm to the plaintiff, which happens due to certain kind of commercial interaction between the website owner and the user, so in that case, the court shall have the jurisdiction to hear and decide the case where the plaintiff resides. Second case is the Myspace Incorporation versus Super Cassette Industries Limited. Now in this case, the Super Cassette Industry Limited, they were having their office in Delhi as well as in Mumbai. And myspace.com, it was a website which was operated from USA. And the songs which belongs to Myspace Incorporation Limited. Now this was a T-Series owned company basically, and which was having certain songs which were on the websites of the Myspace, and they were offering these songs. Myspace.com, it was offering those songs for subscription to the owners or to the users worldwide. So in this case, when Super Cassette Industry Limited, they comes to know this fact that these kinds of activities, they are carried on by Myspace.com. So they brought a suit for violation of the copyright, infringement of the copyright before the Delhi High Court. And when this suit was brought before the Delhi High Court, the defendant, that was Myspace.com in this case, they raises certain kinds of objection before the Delhi High Court. And these objections were, first one is that they said that the defendant is not under the territorial jurisdiction of the court. The defendant is a foreign national. That means Myspace, as I have told you, that the Myspace, they were carrying their activities from US. So they said that since they are the foreign nationals, so they are not under the jurisdiction of the Delhi High Court. Secondly, they said that no part of cause of action has occurred within territorial jurisdiction of Delhi High Court. So again, they said that Delhi High Court, that do not have the jurisdiction in this case. Then they also took another objection by saying that the defendant is not willing to the jurisdiction of the Delhi High Court, and therefore, since the defendant is not willing to, so the court cannot compel the defendant to be under the jurisdiction of the Delhi High Court. So in this case, the Delhi High Court took the opinion that to sue a foreign defendant, the foreigner must be a resident of and carry on business within the jurisdiction of territorial jurisdiction. This was a first thing. But the court also held that this rule now, however, it is not absolute rule, and the foreigner can itself subject to the jurisdiction of the court. But if not done so, the foreigner do not himself subject to the jurisdiction of the court. Now, if the domestic law provides otherwise, in that case also the court can apply the jurisdiction. As we have discussed the Indian Copyright Act, and I have told you that the Indian Copyright Act, it has a different and a very unique kind of rule, which is a plaintiff centric rule. In that case, if the violation of copyright is done, then the court can try the defendant under the operation of the Indian Copyright Act. And same was the case in this case. The court held that since the plaintiff in this case that was having an office, that means the Super Cassette Industry Limited, they were having their office in the Indian territory, that means in Delhi as well as in Mumbai. So the court found the jurisdiction in this case on the basis of the Indian Copyright Act. Secondly, the court also said that the CPC is also applicable, and as per section 20 of CPC, the jurisdiction can also be applied. Reason being that though Myspace that was carrying its activities from the any foreign territory, that means from US, but the court said that the impact of that activities that happens in the Indian territory also, or their impact was also felt within the Indian territory also. So the court said that on that basis also, the court, Delhi High Court, that is also having the jurisdiction. Now this is it, how the Indian courts has interpreted the provisions relating to the cyber jurisdiction. Now coming to the conclusion. So with the discussion which we have gone through during this session, now we can find that cyber law, it is still in its development stage. Now it is just we say that just the 2 or 3 decades back that the internet that comes into the society, and still the law relating to the internet, that is in its stage of infancy, it is in the stage of its development. So it is very much required that a supportive environment that is awarded to the internet or to the cyberspace for its growth. And further, for the purpose of the jurisdictional issue, which happens to be in the cyberspace, it is very much required that certain sort of cooperation between the national as well as the other countries, international countries, that must be there. As we have discussed that there might come certain issues where the offense is committed by one person in one country and that person fled away into certain other territory. And unless the other countries to whom that person has fled away, that country is willing to give that person back to the country in which that offense was committed, so it becomes difficult sometime that in the territorial country where the offense was committed, that person will be prosecuted or punished ultimately. So that sort of compromise or agreements between the countries at the national and international level, that needs to be there. So this is about the jurisdiction. Thank you.